Today, give me credit. We're honored to welcome Jacob Hippensteel, founder of the Hippensteel Law Firm. At the center of our conversation is one of the most powerful consumer protection laws ever written. It's called the Fair Credit Reporting Act. Originally enacted in 1970 and amended over the years, the FCRA gives private individual citizens the legal right to ensure that the information on their credit report is both accurate, verifiable, and documentable. That right isn't theoretical, it's enforceable. And understanding how this law works is critical for the average consumer navigating credit reports, credit scores, and disputes. Now, Jacob Hippensteel litigates FCRA cases nationwide against credit bureaus, banks, and data furnishers on behalf of consumers harmed by inaccurate reporting. His firm handles a high volume of credit reporting disputes and brings a systems-driven approach to litigation, building processes that allow for a significant caseload while maintaining the quality and integrity of each case. Today, we're going to break down what the FCRA means, how it applies in real-world situations, and what consumers need to know if the information on the credit report is wrong. Now, you can contact him direct, as you'll see on the screen, at 480-319-9091. Or, again, as you can see on the screen, his website, Hippensteel, that's Hippensteel law.com. We also have on, as we usually do, J.S. Waldo, an expert in the field of, God, my brain went frozen.
Well, that's okay, John. You're the credit genius, and I'm the mortgage underwriter.
Well, I knew that.
Together, we're all things credit.
At my age, the brain goes blank sometimes. So, anyway, without ado, JS, thank you. Jacob, thank you for being here. And we'd like to ask you some questions, Jacob. Why don't we first start off with your own, what you feel about what we're about to talk about today. This is your sole law practice. This is what you do.
Yeah, that's right. Yeah, John, and thanks for having me. JS, thank you for having me. I anytime I have the opportunity to be able to speak about credit reporting issues, it's something that I like to do because there's a massive, informational gap between what people know about the credit system and what they know about being able to impact the credit system or fix things on their credit report or receive some kind of help in doing that. And so anytime I can help share that kind of information out there, I think it's something that I always want to make the time to do. And I appreciate people like you and JS that are helping to educate consumers about their options, their rights, their these protections that are in place for them that they may not know about. And like you said before, most of my practice is devoted to helping people with credit reporting errors. And it's one of those things that there are probably more people than I could ever help that have credit errors, at this exact moment. And there's many, many attorneys that do this type of work. And I always, when I speak to them at conferences or conventions, I'm always saying that, all of us could be busy from, morning to night, every single day, helping consumers with these types of issues, and we wouldn't even be making a dent in the amount of issues that exist. And when I say issues, I mean errors on people's credit reports that are impacting their score, impacting their creditworthiness, impacting an underwriter's decision about granting them credit. And those are, things that most consumers are outmatched in that situation. They're dealing with multi-billion-dollar corporations who have entire systems set up to make sure that one, they don't have to properly consider dispute letters or even have to look into these things, and two, to make sure that whatever the creditor says is is what gets put on the credit report. Not to go on too long on this, but I think one of the biggest misconceptions people have about Equifax, Experian, TransUnion is that they, the consumer, are the customer. And they're not. The banks are the customer. The banks are who's paying to use these services and who benefits from these services, not the consumer. And so people are usually surprised when they dispute something on their credit report, and the credit reporting agency just defers to whatever the bank said. Well, that's because the customer is always right, and they're treating their customer, in a way that's going to benefit their customer, the bank, not the consumer. And so, going back to one thing I said before, that they're usually outmatched in these situations, and that's where lawyers like myself step in and can help them, get the actual results and justice that they need in that situation.
Well, thank you for that. And, there's so much misinformation out there, and we're going to go over a little bit of that. One of the questions deals with that we have for you. We want to first start off with the foundation, and JS has a question for you.
Yeah, I think the first thing that I want to go into, and thank you, Jacob, for being here. This is great for us. We've talked about this topic so much. It's near and dear to our heart. It's the foundation of all of our education. So, Jacob, if you could just for a moment give us an explanation for the audience, for us in the audience, what are the basic rules for the Fair Credit Reporting Act?
Yeah, that's good. Yeah, and I think that is a good starting point, because a lot of what we'll probably talk about going forward is going to be built on this. So I think the biggest component here is that you are, as a consumer, you're entitled to have an accurate credit file maintained about you. And it's an interesting thing, because you don't necessarily have a choice on whether one of these companies decides to maintain a credit file about you. I think a lot of people are surprised to find out that they have consumer reports about them in different ways. And I know we'll probably touch on this later, but we usually talk about Equifax, Experian, TransUnion as sort of the big three credit reporting agencies. But there are a lot of different credit reporting agencies, or consumer reporting agencies, as it's used in the FCRA. One of the most fundamental rights that's provided to you in the FCRA is the right to have accurate information maintained about you. And for our purposes, I think one of the things that you have some control over is not necessarily what information gets placed in the credit file that's maintained about you, but you get to dispute information that you think is inaccurate. And the way that is supposed to work by law is that you can dispute the information in your credit report, and what comes back from that dispute should be one of three things. Either the information has been verified as accurate, and then it stays in your credit file. The information's been determined to be inaccurate, and then it comes out of your credit file. It's deleted from your credit report. Or they don't have enough information to verify or not the accuracy of the information. And in that case, the information is supposed to be removed from your credit file also. I think that's the piece that people don't always understand, or don't always recognize, that you should be getting one of these three outcomes every time. And a lot of times, people are frustrated when they're disputing something that they know is inaccurate, and it's just not changing in their credit file. And that is the next piece of kind of the FCRA and what your rights are there, is if you're disputing inaccurate information and it's not changing in your credit file, then you do have the right to sue the credit reporting agencies and the bank who is furnishing that information to get that information corrected and to recover some type of damages for whatever harm they've done to you.
Yeah, thank you. That you touched on something though. We all think there are three credit reporting agencies, right? You said it: Experian, Equifax, TransUnion. And the FCRA governs those. But I know, because John's a great educator, that there are well over 40 credit reporting agencies in total that collect data. So my question to you is, does the FCRA govern those also?
Yes, absolutely. Yes, it does. And there are different types of credit reporting agencies. So Equifax, Experian, TransUnion deal with primarily consumer credit. I mean, that's mostly what they're looking at is credit cards, auto loans, mortgages, things that the average consumer would be using. But there are credit reporting agencies that are maintaining files on most consumers about their checking account use and whether they've ever, wrote a bad check or anything like that. There are whether they've overdrafted their accounts. All that information is kept in a different type of credit reporting agency. There are also, I think some people are familiar with this, and we're seeing a lot more of this, but background check companies that maintain information about any kind of criminal convictions or any other registries.
They collect data on employment. They collect data on, believe it or not, the pharmacological or the pharmacy use that you have. So the question is always, for me, where does this, if they're collecting it, someone's buying it. So who's buying it? And that's a question for me. I don't necessarily need you to answer that. If you can, that would be great. But, if there are 40 of them out there, and I'll be putting this out here shortly on what I do on the different 40, all the 40 of them that are there. So the question is, do you have a right to a copy of those?
Yes. So I think that is, yes, you have a right to obtain a copy of it. You have a right to dispute information that's in that file. That's absolutely part of that and covered by the FCRA. The issue is identifying who these people are that are maintaining this information about you and how to go about getting a copy of the report. I think we see a lot of people that will, a lot of consumers will they have troubles getting approved for a new utility setup, and they're just not aware that this is, that there's a credit file. NCTUE is maintaining this information about how you pay your utility bills, and you may not know to go look for that to be able to even obtain a copy of it and dispute it. Generally, though, I mean, if any adverse action is being taken against you based on information in that credit file, you should be getting a notice pursuant to the FCRA that, hey, we're choosing not to extend this to you based on the information in this file. And then you're able to go, find that file and look into it. People, in employment context will see it that way. If a background check comes up with something, they'll get a notice right afterwards. I think in that context, they're much more consistent about providing those kind of notices. But all of these different credit reporting agencies that you're talking about, if they have a file about you, you should be able to get a copy of it, and you should be entitled to dispute inaccurate information that's in that file. And it should all flow just the exact same way that it does for Equifax, TransUnion, Experian. And
if they don't send it back to you, what rights do you have? Can you sue them then for that? Or you can. There's usually, I don't normally maintain lawsuits specifically just on that. I will sometimes on like consumer credit reports if somebody's tried repeatedly to get a copy of it and for whatever reason the credit reporting agency is not providing a copy of that. In that instance, then I will sometimes sue the credit reporting agency for that. Generally, though, we really just want to get the report. And so whatever we can do to actually get the report is usually the better option there, which sometimes involves the lawyer reaching out. Sometimes it involves just being more persistent. It used to be that you could get around this with making a CFPB complaint, and just that would get enough attention to get somebody to respond to you from one of these credit reporting agencies. It seems like that's less reliable now, but to put it mildly. Yeah.
Well, let's not go down that rabbit hole right now. Let's back up.
No.
Let's back up for a minute, because I want to talk about something you touched on. You touched on disputing, and it's hard if you don't know who to dispute to. But let's first start with, if you could explain the process of what happens once a credit reporting agency receives a dispute letter. What happens on their end?
Sure. Yeah. This is another, for most consumers, it's a black box. They know that they've sent in a dispute and they have no idea what happens after that. And out the other end comes their credit report that's still inaccurate, and they're not sure why. First, I will say that the process for the credit reporting agencies is a volume process to the extent that it's hard to imagine. The number of disputes that these companies receive daily is astronomical. And so if they didn't have a statutory requirement to investigate these disputes, they absolutely would not, and would not be able to keep up with the demand for it, or the volume of these disputes. Because of that means, the reason they have to do this is that they're statutorily required to do this by the FCRA. And so they do everything they can to streamline the process. And streamlining the process usually is not the same as having the most effective process. And so when you submit a dispute, usually what's happening there is it's getting coded into, electronic terms, and that's being submitted through to the data furnisher. And they do it through a system called eOscar. That's the software that's being used to transfer information between credit reporting agencies and furnishers. And so they're passing over the information that just says, okay, this person is disputing this account for this reason. And usually that's it. A lot of times they're not even passing along the letter itself or any supporting documentation that you may have provided. And I think that's one thing that can be very frustrating for consumers, is that, hey, I paid this account off, but it's reporting a balance. Here's the proof that I paid it off, and they send that in. But that doesn't always make it to the furnisher. And so the bank doesn't always know that, you have proof that you've paid off this account. The other thing is that because of the extremely high volume of disputes that credit reporting agencies receive, they process them extremely fast, which means there's very little time for any actual thought to go into reviewing or investigating the dispute. I think for that reason, I always recommend to consumers and some of the credit repair businesses that I interact with on how to structure their disputes to just be as plain language as possible, as simple as possible, so that it's very black and white, that this is what's wrong, this is the exact account, this is why it's wrong, and this is how it should report now. I think that's the template that I think is most effective in getting things corrected on credit reports. And if it's not getting corrected on credit reports, it's also the template that's most effective for me as an exhibit in litigation to say, look, if any rational person had looked at this, you can very clearly see what's wrong on this credit report and why it should be different. The thing is, though, whatever tools that the credit reporting agencies are using to handle this volume of disputes are not always catching these kind of basic things that any rational person would catch in the letter or understand out of the letter. And so they screw this up constantly. Obviously there's thousands and thousands of FCRA lawsuits filed every year. For every lawsuit that's filed, I'm sure there's another 10 that, violations of the FCRA that exist, and that person just wasn't able to find an attorney to help them or doesn't know that they could find an attorney to help them. But the number of violations that come from that process that we're talking about now, of once the dispute has gotten to the credit reporting agency, that's the bulk of my practice, is that right there, is that process getting screwed up.
All right. We're going to walk through the process, and let's going into tactical application. Is the wording of a dispute letter important?
Yeah, I think it is. I'm a big proponent of, like I said, just plain language disputes. I think one thing that I see a lot that I think just confuses the issue a lot of times is I see a lot of disputes provided to me from credit repair companies or consumers that found something on the internet that they're then bringing back to me. And it's disputes that have just all types of legal citations to laws that don't even apply, or to specific factual, or specific statutory cites to the FCRA, which that's not, I've never seen that be like the make or break issue in a dispute letter is, oh, the credit reporting agency didn't know that they were subject to the FCRA. Thank goodness this letter calls that out and highlights this for them. They know what the law is. There's no confusion on that. The issue that you're disputing with them is a factual issue. It's not a, yes, it's governed by a law, but it's not a legal issue that you're deciding with them. And in fact, the credit reporting agencies will tell you that they don't have any obligation to investigate legal disputes, that all they're supposed to look at is factual issues. And because of that, we try to structure all disputes in a purely factual way. And my kind of rule of thumb when I'm teaching, my paralegals how to prepare disputes, or when I'm teaching credit repair companies how to prepare disputes, is to explain this like you're explaining it to, a family member who has no understanding of how credit reporting works. Because then you're probably dumbing it down enough to keep this a purely factual statement about the account. And so, the example I'll give there is this account reports a balance. It should not report a balance because I paid it off on this date, or, I paid this off with this debt collector, or however it was ultimately paid off. Because of that, I'm requesting that you update the balance to 0. That's as plain as you can be about that type of issue. And for every type of issue that I've seen or error I've seen on a credit report, you can always distill it down to a very plain factual statement like that just identifies, this is the account in question, this is what's wrong with it, this is why there's something wrong with it, and this is how it should be reporting going forward. And that is, in my experience, that's going to be the best dispute for a couple of reasons. One, because it leaves no ambiguity as to what the credit reporting agency should be doing. And two, for my purposes, because I know that this gets messed up so often and that so many of these result in litigation, that's a great exhibit in litigation for me, is a dispute that, we can blow this up and put it in front of a jury and they can see exactly what's wrong with the account, at a distance. That's going to be perfect for our purposes.
Okay. The e-Oscar system takes the reason you're making it a very basic thing, the dispute going out. So the e-Oscar they're going to take that information in that letter, put it into the e-Oscar system. It ships off to the creditor. The creditor ships it back saying yes, no, maybe. And then you get a letter back, a response back. Now, you see a derogatory item on your credit report, and it may look correct, but you wonder if they can prove that. Now, we're talking about the verifiability of it. Can you challenge any debt on the credit report to determine the veracity of that debt? In other words, do they have the ability to prove it?
Yeah, so yes, I think, so this is a place where I think there's friction in my mind between like the legal requirements and just the concept of credit reporting. And so, in my view, if Experian is going to maintain information about me, they should have proof that the information they're maintaining about me is accurate. And so exactly what you just said, any account in my credit report should be subject to me disputing it and then being able to verify it with evidence. Hey, I contacted the mortgage company and they said, this is the current balance of your mortgage and that's why we're reporting this information. They should be able to say that about every single account on the credit report. They can't always do that. And mortgages is probably a bad example there because, obviously most mortgage companies maintain good records. The thing that's more likely in that situation is debt collection, accounts that have been sold off, medical debt that's been transferred around from, the practice to a collection company and back. Those are the situations where you see unverifiable debts more often. The place where I say there's some friction here, though, is that under the FCRA and in every circuit around the country, there's good case law that for the credit reporting agencies, accuracy is going to be a complete defense to any FCRA violation that you've identified. So if it ultimately is accurate, whether they could verify it or not during the dispute phase, then they're not going to have liability for for reporting that information. And so that's the place where I think the practicalities of the fact that they maintain these databases full of information about all of us, and that some items in those databases can't be verified. It's unfortunate that, once we file a lawsuit saying, hey, you couldn't verify this information and so you should have deleted it, well, now all of a sudden they have the documentation to be able to verify it. Once a real person is involved in the process, they're able to track down that information. And occasionally that doesn't happen. Occasionally we see that they're unable to verify it. They will quickly decide that they don't want to report this information anymore. Usually that happens where they've, a debt collector that they've fallen out of contact with, and they're no longer getting updates from that debt collector, and that's where they'll delete that information. Otherwise, we see it plenty that now that we're in litigation, they complete an investigation, which is probably what they should have done when they first received the dispute letter, but which they didn't do because they offload all of that onto the e-Oscar system, pushing it over to the furnisher, just accepting these responses back. There's a term that we use with FCRA which we say is parroting. And so the credit reporting agency can parrot the information that the furnisher says, whether the furnisher's actually looked into that information or not. And I guess I should be careful about the way I said that. It's not that they're allowed to do that, it's that they do that very regularly. And so the credit reporting agency receives a dispute. Let's go back to the example I used before. I say I paid this account off. I paid it off on this date with this debt collector. It shouldn't have a balance anymore. They send that information to the furnisher. The furnisher just responds back saying, we verify that account as accurate, or that trade line as accurate. The credit reporting agency gets that. They turn around and they say, yep, this is accurate. It was verified. But they're not looking at how it was verified, if there's any actual information behind that or any actual record keeping behind that. They're just parroting what the furnisher had said in that instance. And there is good liability there to be able to sue the credit reporting agencies when they do that. I mean, they should be involved in this process and actually looking at the information that's being provided to them. And that's one thing, John, I know you and I have talked about this offline on certain things, but one aspect that I typically will include in all dispute letters is language that says, if you're unclear about any of this or you want more information, reach out to me, the consumer, or reach out to the furnisher directly to verify this or to communicate about this, because that's something that's completely missing in the e-Oscar system. There's no way to, nobody reviewing these disputes has an option to turn around and call the consumer and say, hey, what do you mean by that? I'm looking at this, but what are you seeing here? Which, if they wanted to be perfectly accurate, if they actually wanted to maintain accurate information, they would do that, because that's how this process should work or could work if that's what we were after, is maximum accuracy. But again, the consumer is not the customer of the credit reporting agency, the furnisher is, and that's why they parrot that information is, well, my customer said this is accurate, so I'm telling you it's accurate, and that's the way that those get resolved.
In my business, when I was doing credit repair along with the credit education, my second challenge, after we got the answer back that it wasn't removed or wasn't changed or whatever, we would send a letter directly to the creditor. And that was my second step in this process. And believe it or not, we got a lot of them removed based on the challenge directly to the creditor, because now you're sending in the documentation directly to the creditor that they may not have gotten with the e-Oscar system. Do you recommend that also?
Yeah, I think that's a powerful step, and vice versa also. I think you'll have many situations where a consumer is disputing with the credit reporting agencies and not getting anywhere. But if they were to send something to the creditor, then somebody would look at it and it would potentially get corrected. The flip side of that, though, is you see a lot of times, I see this with identity theft a lot, where the victim of identity theft will be going back and forth with the creditor for months, not getting anywhere with them, and then come to me and say, hey, I'm at my wit's end. Can we sue somebody? Well, no, because you haven't actually triggered the FCRA yet. You haven't sent a dispute to the credit reporting agencies. And so that's kind of the flip side of what you're saying is you need both. Right. You need to have the furnisher communicated with directly. You need to have the credit reporting agencies communicated with directly. And that's going to be the thing that actually gets you results, is somebody will do what they're legally required to do in that situation. And if they don't, then now you've essentially perfected your claim that now we can go into court saying, look, we tried everything. We gave them every opportunity to fix this. They would not do it. And that's why we're here. That's why we're here in federal court asking for, redress for the harm that's been done to this consumer. And so, yeah, you need both.
Yeah, so that conversation leads me to something that John and I have talked about many times on our show here. We've all seen the ads, right? In the social media, you see them all over, about a thing called the credit repair loophole. Is there even such a thing, or is that just marketing?
Yeah, mostly marketing. So I see those things also.
BS marketing.
Yes, thank you. Yeah, you said it. Yeah, that's exactly it. I've seen those also, and I think it's amusing to me that some of them will say like the Section 609 loophole, or you're just describing the dispute process. You're not. This is the FCRA that you're talking about. It's not some like hidden thing that nobody knows about. This is you're describing and selling back to people something that is their legal right already, and I think that's my concern when I see those things, is that they're putting behind a paywall or behind a very pricey upfront fee structure subscription the process that every consumer is entitled to engage with on their own. And I think there's a lot of bad information, there's a lot of bad service that happens in the credit repair industry, but there's also a lot of people in the credit repair industry that are trying to help consumers and trying to do it the right way. And it's frustrating to me to see, some of the companies that have these credit sweeps that they'll do, or these credit repair loopholes that they do. And it's very good marketing. I mean, they have great, the TikTok videos are getting tons of views on that, but it's not always leading to great service for the consumers or actual results for the consumers. And I think that's a piece that I get frustrated with, is that there's a lot of people in that industry, the credit repair industry, that are doing it the right way, but are not using these buzzwords or these flashy things that are, as John said, just BS marketing. And that means a lot of consumers are getting funneled into these programs where they're paying a lot for something that doesn't do a lot for them. And I think that's frustrating. So no, though, to answer the question, there's no loophole. There's no secret that some company just formed last week knows about that nobody else knows about. That's no.
Yeah. You see that so much, Jacob.
Yeah.
I just see that a ton. Or never pay off a debt collector. They don't own the debt. Or even if they own the debt, they weren't the originator of the debt, and thus you don't have to pay them. Period. Yeah. And that's where they leave it. It's like, it's all BS.
Yeah. And we've actually done entire episodes on that, because we're quite passionate about people being taken advantage of. So thank you for that very much. I think that the marketing is brilliant. They're playing on fear, unfortunately.
Yeah.
Right.
What's the difference between negligence and willfulness under the FCRA, and why does it matter?
Yeah, so those two things are, I guess, the differentiators between what type of damages you can recover under the FCRA. And really what we're talking about is the conduct by the credit reporting agencies and the furnishers, and whether it was, merely negligent, I think is a difficult way to put it, because, as I mentioned before, the systems that they've designed and put in place to handle their responsibilities under the FCRA are usually not done in a way that would, what they're supposed to do, ensure maximum possible accuracy of the information that's in that credit report. But we can say that, that they were negligent in handling something. They just mishandled it. And because of that, that's, one category of damages you can reach is then your actual damages. So, whether you have out-of-pocket harm that occurred, or most cases, I think sorry, there's going to be a slight digression, but under the FCRA, you're able to recover damages for things that happen after you have disputed the inaccuracy. So after you've put a credit reporting agency and the furnisher on notice that something is inaccurate in your credit file, anything that happens after that are damages you can recover. Anything that happened before you ever disputed anything are not damages that you can recover. And so I think a lot of times people will have, a situation where they were denied credit, then they go find their credit report and they see that there's something inaccurate on there. They dispute that information, it doesn't get corrected. Now they want to sue and recover damages for the fact that they had been denied credit previously. But that's outside of the window of what's recoverable under the FCRA. And so for that reason, I think a lot of the cases I see will deal with, most of the actual damages that they have are just going to be considered emotional distress. It's aggravating to deal with this process. And because of that, there should be some financial compensation to the consumer because of that.
Yeah.
But if there are, go ahead.
No, I was just going to say, you're kind of leading into my next question, which is what types of damages can consumers realistically recover when they're suing?
Right. Yeah. And so on those negligent violations of the FCRA, then they're able to recover these actual damages, which it can be the cost of a lost credit opportunity, which is what you'd be pursuing if there was a denial that resulted directly from the inaccurate information in the credit report. But as I mentioned, most of those damages that you're looking at in the average FCRA case are just those emotional distress damages. And so, which that can be hard to quantify. I mean, if I told you, hey, put a dollar amount on the frustration that you'd feel by having inaccurate information on your credit report for 6 months and after multiple rounds of disputes, I think most consumers and most of my clients, it's hard for them to put a dollar amount on that or to figure out even how you would go about putting a dollar amount on that, which is, again, one of the reasons why consumer attorneys like myself have a job, is because, we've done this many times and know how to sort of lean into what those damages can look like and what they can be presented as. The other type,
you've got, as you described earlier, case law, which is different than the law itself. So this case law is laws that are, what do I want to say here? They're based on the law, but they're adjudicated already, and you can use those as backup.
Yeah, that's an interesting thing that I think you touch on the legal process enough, John, that you're familiar with this type of thing. But I think a lot of people get frustrated with that, well, here's what the FCRA statutes say, but that's not the end of it. Also, we have all of these courts that have looked at that law and then interpreted how that should be applied to different facts, and then decided that, here's a bright line rule that we're going to apply to all future cases that resemble this type of issue. And so, you end up with requirements or elements to prove things that are not written in the FCRA itself, but become part of the overall law of, using the FCRA to assist consumers.
Yeah.
Right.
Okay. Is it ever too late to sue?
It can be. For most consumers, it's not too late. I think a lot of people will worry about like, oh, well, this was from a couple years ago, so it's probably too late. I don't want to mess with this. There are strict timelines on the FCRA. I mean, it's generally 2 years from when you became aware of an error. That's a limitation. You have a statute of limitations that says you have to file a lawsuit within 2 years of you becoming aware of the error. But the error is usually once you've disputed that information and it's come back verified as accurate, even though it's inaccurate, that'll be the error, is the mishandling of the dispute process. That's the actual thing that you're suing for under the FCRA. So 2 years from that, which the reason I say for most people it's not too late is because, okay, I disputed this 2 years ago, but it's still on my report. Well, okay, dispute it again. And now we got a fresh 2 years in which to file a lawsuit. And so for most people, you aren't ever too late on that. There is, though, an issue where in the FCRA, it's 5 years after the error, first appeared. You have to file a lawsuit within those 5 years. Otherwise, you're unable to file a lawsuit in federal court for that. And so you do sometimes have that come up with The places I've seen that are like identity theft issues for somebody who doesn't use their credit all that often, and won't have seen their credit report that they have this on there, and they'll look and say like, whoa, 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 what are all these accounts from 6-7 years ago?
Right.
And unfortunately, at that point, it's probably too late for them to file a lawsuit. Sometimes we'll try and restart some things or see what we can do to restart the clock on that, just because those people deserve to get help also. It's just that they happen to fall outside that timeline. So, but yeah, for most people, you redispute it and you got a fresh 2 years to file a lawsuit. Even though, even with that, I would recommend for most people, act quick on this stuff. The damage that it can cause to you for higher insurance rates when you renew that, any credit cards you get during the meantime are going to be higher rates. All of this stuff can have some pretty lasting impacts in the background that you're not necessarily aware are happening. So that's why the recommendations are out there to regularly check your credit report, see if there's anything on there that's inaccurate, because the worst time to find out that you have an error on your credit report is, hey, we just submitted this mortgage application. My dream home that I've been, my heart is set on this house and no other house will ever make me happy. And now you found out you got an error. Well, sorry, but we got a 30 to 45 day dispute process, then probably another round of disputes, then a lawsuit. And, I pride myself on getting people through lawsuits quickly where we can. But even at that, we're talking about 120 days to get through that at the extremely fast end. And so, when you need your credit is not the time you want to find out that you have a credit error. So,
I just did a Substack on this post, and I equated it, and in fact, it just came out yesterday, where I equated it to the spring training in baseball and what's going on with that. You don't wait till the Game 7 of the World Series to adjust your swing. You got to be practicing this all the time. And that's why JS and I have this mantra that we end almost any podcast that we do with, where do you go to get your free credit report? And people are still under the misunderstanding that you can only pull them once a year from each bureau. Right now it's once a week. And so to get people to look at their credit reports, I feel like a broken record. Get your credit report, get your credit report, get your credit report.
And where do they get that credit report, John?
Huh?
And where do they get that credit report, John?
Annualcreditreport.com.
There you go. And if you haven't done it, again, we are begging you. This is very important. You have to protect yourself. As John says, stand tall. You cannot stand tall if you don't even know the information that's out there.
That's right. Because everything you're doing financially now is being judged by that credit report, especially since FICO scoring started. Mm-hmm. It baffles me, but I'm easily baffled at my age. So,
well, let me. I think you've already kind of hit on this, Jacob. But let me just ask you one final question from myself. John may have another, but from me, what do you feel is the one mistake consumers make when dealing with creditors or credit bureaus that cost them control?
Yeah, I think, well, there's a couple of things. I mean, like on the debt collection side, I think not documenting your communications, not keeping record of who you spoke to, when you spoke to them, that type of thing. And that's, like I say, most of what I focus on is the FCRA. So most of what I focus on is credit reporting. But the debt collection, I guess, industry is always involved in that in some way. And so, yeah, in that regard, documentation, accurate note keeping, having records of everything you've done there, I think is a huge part of that. On the credit reporting side, it's it's what we were just talking about, knowing what's out there, knowing the information that's being provided about you, and having some say in that. And I think that's the piece that the exactly what we just talked about. You find out about it when you need it most, that there's something wrong with your credit, and that's the worst time to deal with it. And you do lose control in that situation, because now your back's against the wall. You either, too often I see people will decide not to pursue a dispute because they're already in underwriting and they don't want to have anything in dispute on their credit report. And well, okay, but this information is inaccurate. We need to get this corrected at some point. And I think that's the exact situation of losing control there, because you waited too long. You weren't proactive about your financial health. So yeah.
You know, I don't know how much I had to pay for you to say this, but I'm just kidding. You didn't pay me. The debt collection you were talking about. I just wrote a course and I'm just in the process of getting it out there. And you mentioned that because there's so much misinformation about that and how to deal with it. So just folks know that that's coming out soon. And I think we should wrap this up now. We've been on much longer than I had anticipated at this point. But Jacob, I can't tell you how much your participation meant and means to both JS and I. You're extremely articulate. You're very good at what you do. And if people don't contact you for information about the FCRA, they don't deserve credit. No, I'm just kidding.
I appreciate you taking that last step there. Yeah, I'm very open about this information. I'm very, I want to spread as much information because exactly as I mentioned at the start, I mean, so many people have errors on their credit report and they don't even know it. And
right.
And they need to get help with it because, like I said, you don't want to wait.
Could be a last name. Could be a last name.
Yeah.
I mean, misspelling of the last name. Maybe your social security number is even wrong on the credit report, because many times, on your social security number, and I read this somewhere many years ago, that only 7 numbers have to match, and they can pull you up.
I could go on for a long time about this because we've been going another hour here, John. The way that they place accounts on your credit report and the way they do data matching to identify is a situation that it's self-fulfilling in a negative way. So if you have one negative, or if you have one item of information that doesn't belong to you, go onto your credit report. And this could even be, this is another digression here. This could even be you apply for credit and whoever is entering your information fat fingers your social security number. So now a social security number that's off by a digit or two is associated with your credit file. And now any accounts that are associated with that incorrect social security number will have one data point match with your credit file. And so
right.
That could potentially get that account put on your credit file. Now in the future, if other accounts that don't belong to you see that credit, that trade line and that wrong social, well, now there's 2 data points. And now it's more likely that they put more information on your credit report. And this is mixed files is what we call this. It's a mixed file situation. And it is, I don't know that it's worse than identity theft, but it might be, because it is incredibly aggravating to get a mixed file fixed. I always tell people, you think you have a mixed file, contact a lawyer immediately, because suing somebody is the only way you're going to get that corrected, because you can dispute it till you're blue in the face and it won't get corrected.
So I'll end this by saying, folks, stand tall. You've got the information. You've got a great resource here in Jacob, in what he does. And if you don't use them, I'm repeating myself now, but if you don't use them, you got issues, because he's the brains. He's the brains. So with that, JS, go ahead.
Yeah, thank you everybody for tuning in and listening. Again, Jacob, thank you so much. I really look forward to talking to you again. You have given us so much information. You can follow John and I on our Substacks. And Jacob, again, we're going to have your information right on the screen for the consumers. Please go pull your free credit reports. Like and subscribe. As always, as they say on YouTube, ring that bell. And thank you, everybody. Have a wonderful day.